So hello everyone, my name is TUSHAR and today I'll be covering general exceptions in IPC. So what is general exceptions? Under section 6 of IPC, throughout this code every definition of the offence, every penal provision and every illustration of every such definition or penal provision shall be understood subject to exceptions contained in the chapter entitled General Exceptions. General principle. First we'll talk about burden of proof, in which the general principle is that the prosecution has to prove its case beyond reasonable doubt against the accused. As per section 105 of Evidence Act, a claimant of general exception has to prove the existence of situation of general exceptions. Burden of proof in general exceptions. It lies with the accused under the case of KM Nanavati versus State of Maharashtra 1962 AIR 605, Dayabhai Changanbhai Thakkar versus State of Gujarat, and section 76 bound by law. Nothing is an offence which is done by a person who is or who by reason of a mistake of fact and not by reason of mistake of laws in good faith believes himself to be bound by law to do it. So bound by law or by mistake, but not by mistake of law, in a good faith believes himself he is bound by law. These are the main things which are covered by section 76. Section 77 Act of Judge. Nothing is an offence which is done by a judge when acting judicially in exercise of any power which is or which in good faith he believes to be given to him by law. Section 77 Act of Judge also states that a collector while exercising power under Land Acquisition Act is neither a judge nor acting judicially, which was covered under case of Sundar Kumar Bhatia versus Kanhaiya Lal and others, AIR 2009 SC 1961, in compliance of court order. Section 78. Nothing which is done in pursuance of or which is warranted by the judgment or order of a court of justice, if done which is warranted by a judgment or order remains in force, is an offence, notwithstanding the court may have had jurisdiction to pass a judgment or order, provided the person doing the act is in good faith, believes that the court had such jurisdiction. And in section 79, which is justified by law, nothing is an offence which is done by any person who is justified by law or who makes a reason of a mistake of a fact and not by reason of mistake of law in good faith believes himself to be justified by law in doing it. Which it was also stated in Upar Cinema case, element of good faith was lacking as the accused did not act with the proper care and caution required by law, covered, and also a case of Sushil Kumar Ansal versus State through CBI 2014 Supreme Court case 173. Accident in doing a lawful act. Nothing is an offence which is done by an accident or misfortune and without any criminal intention or knowledge in the doing of a lawful act in a lawful manner and with the proper care and caution. Section 81 to prevent other harm. Nothing is an offence which is done with the knowledge without a criminal intention in good faith to prevent others harm to a person or a property. Act of an infant under section 82 of IPC, which is act which is done by an infant which is below 7 years of age. Act of child of immature understanding, which act should be done by a child who should be above the age of 7 years and under 12 years, immature to understand, to judge the nature and the consequences of that act, is not applicable on the immature person who cannot understand the same. Act of a person of unsound mind. Nothing is an offence which is done by a person who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act or that he is doing what is either wrong or contrary to law. So it is a person of unsound mind has incapable of knowing nature of the act, he is not aware of that, either wrong or contrary to law. Section 84 Act of person of an unsound mind. It was under a case of Hari Singh Gond versus State of Madhya Pradesh, AIR 2009 SC 31. Every person who is mentally diseased is not in fact exempted from criminal liability. Legal insanity has to be distinguished from mental insanity. And section 85 person involuntarily intoxicated. So it is a person who is incapable of knowing the nature of the act, who has done a wrong or contrary to law due to intoxication administered against his will, which he was not supposed to do and he was not willing to do. So, and he does not have the knowledge to do the same. But it was the nature of the intoxication which it becomes a reason, and he is incapable of knowing the nature of the act which he has done, either wrong or contrary to law. Intention or knowledge if intoxicated. So it is required for the particular knowledge that if he is aware about the person the accused has known the whole facts and shall presume that he was intoxicated unless it is administered against his will. So in that case, where an act is done and not an offense unless done with a particular knowledge or intent, a person who does the act in state of intoxication shall be liable to be dealt as if he had the same knowledge and he would have had if he had not been intoxicated, unless a thing which administered to him without his knowledge or against his will. Voluntarily caused injuries. Person consented to take risk, expressed or implied, not intended to cause harm. Both were aware of the risk. No offense was constituted. So in that case, if there is a cause or to be intended by the person to cause, who is above 18 years of age, who has given consent, whether express or implied, to suffer with that harm, or by any person of harm which is to be known is likely to cause to any such person who has consented to take the risk of that harm. Act done by consent for benefit. So person consented to take risk, expressed or implied, not intended to cause harm, done in good faith for the benefit of the victim. For the benefit of a child or insane. Guardian consented to take risk of child or insane, not intended to cause harm, done in good faith for the benefit of the child or insane. Consent under fear or misconception under section 90. Consent is not valid consent. Misconception of fact and the person doing the act knows or has reason to believe it is given under fear or misconception. Exclusion of act constituted an offense. Under section 87, 88 and 89, the act is an independent offense and independent of the harm causing abortion of itself, it is an offense. Act done without consent for benefit. For the benefit in good faith, his consent cannot be obtained or guardian is available. No guardian is available does not constitute to an offense. Any communication cause or harms. Communication which is made in good faith under section 93 of IPC states that it is made in good faith for the benefit of the person to the person whom it was made does not constitute to an offense. And section 94 states compelled by threat. If any person compelled to do the same by any act by threat or of instant death reasonably cause the apprehension, act is not an offense except offense of chapter 6 of capital punishment or murder. And the last is act causing slight harm. Nothing is an offense if it is caused or there is known to be likely to cause any harm if that harm is so slight that no person of ordinary sense and temper would complain of such harm. So these were the basics of all the types of general exceptions under IPC which was stated, explained general exceptions which was defined under section 6 of IPC and stated thereon from section 76 to section 95 of IPC. Thank you.